Good evening, this is John Milburn for LAWS12062. This is Alternative Dispute Resolution, and we're into week 10 of 12. Tonight we're dealing with a number of issues, primarily around legal issues, ethics, but first some discussion in relation to two very important generic topics. The first is feedback. As you would have seen, we now have the feedback icon in the top left-hand corner of Moodle. I'll just share the page. Thank you to some of you who have already provided that information, that update. I think, in fact, I'm saying some of you, but it might even be just one. So if you haven't already provided feedback, I'd certainly ask you to do so and invite you to do so. So that hopefully is now the screen that you're looking at, which is Alternative Dispute Resolution. Yes, only one of 54. So you might be looking for some further information from me before you give the feedback, which leads me to the next topic, and that is in relation to the take-home paper. So this afternoon, I released the information guide, and I'll draw your attention to two places on the Moodle landing page. The first is above latest information, where you'll see the clip for the previous week's lecture. You'll see the PDF for LAWS12062 Assessment 2 Take-Home Paper 2019 Information Guide. And I've reproduced that information in the PDF into the body of the material, and I'll leave that there for a little while. There may in fact be some material in the PDF that's not reproduced on the landing page, so please do look at the PDF as well. A couple of key points in relation to that take-home paper. The first is when you complete the task, we'll go to the end and we'll work backwards, as I often do. When you complete the task, you are to upload it as a normal assessment, as you normally would through the assessment module. So follow the links and upload. Do so in a single Word document, not a PDF, a Word, and all answers in relation to the take-home paper should be included in that single Word document. Now, the take-home paper I'll release in week 12, Thursday, the 10th of October at 6:30 p.m. If I'm caught up and I'm a little late, please excuse me, but so far I've always managed to release the paper on time, and I trust that this year will be no exception. Now, here's the thing. It is a take-home paper, not an assignment. And whilst it has many of the hallmarks of assignment, including the way in which you submit the work, it is in fact a substitute for the invigilated examination, the sort of thing that you might have done in other Priestley 11 subjects primarily, which is, of course, a 2-hour or 3-hour, as they used to be, sit-down paper at an examination centre, and you would handwrite the answer using open book exam or closed book exam technique. So the take-home paper is the substitute for that. It's not just another assignment. What that means is that there are some special rules that apply. The first is that no late submission will be accepted. I simply don't have the authority to accept any late work. So you must present your work by 11:45 p.m. on Friday, 11 October 2019. That's a strict time limit. So if you're game, you can leave it to the last minute and submit, or you might want to play it safe and submit just a little earlier to ensure that it all gets through. The system will lock you out. The maximum word limit is 2,000 words. And now the assessment is broken into two questions, and I'll deal with those shortly, of different number of words. So you can play around with the word limits on those two questions a little, but please ensure that the total maximum is 2,000. That said, I'm a little more generous than perhaps I should, and each unit coordinator adopts slightly different practices in this regard. So please ensure that you understand anything that I might do by way of a concession is purely something that I do, and don't expect that from other unit coordinators who may have different rules. So for example, some unit coordinators may say, I'll read up to 2000, the word which is the 2000th word, but after that I'll stop reading. That's a prerogative. I don't do that, but I would recommend you certainly don't go over 2,200. And indeed, if you go over 2,000 words, even if you're still within that 10% tolerance that I've just mentioned, I will look at the work to see more critically whether in fact you needed to go those few words over. If you go well over, then you can expect I'll start deducting marks for inefficiency. So please keep those things in mind. I don't return the marked examination to you. I will provide generalised feedback, but no personalised feedback for this assessment. The first question is one where I present a hypothetical scenario. It will require you to reflect on all of the work that we've completed during the unit. However, it will come as no surprise to you that you should primarily consider the second half of the unit, given that the first assessment dealt overwhelmingly with the first half of what we covered during the content. Whenever you answer a question in law, certainly for me, a general requirement is that you consider any relevant ethical issues. It's not necessarily a hint. It's not saying there is necessarily going to be an ethical issue that you need to consider. But I always want you to at least consider that, turn your mind to it, and it may be that there are ethical issues that you need to consider, particularly given that the week 10 content relates to ethical issues, so it may be directly related to ethical issues. Think about other things such as practice standards, statutory provisions, so legislation, case law, regulations, rules, or practice directions. So if you don't know how to find, for example, practice directions, then please make sure that you learn some of that information and preferably do that before the take-home paper is released. Now, the second question is a review task, and that's more of an essay style response. You can consult with each other at your discretion. So once the paper is released, you can talk about it. However, I need to be very careful here. And again, I adopt potentially, quite probably, a more liberal approach than some unit coordinators. Some unit coordinators may adopt a strict policy. Once you've seen the paper, do not discuss it with anyone else, and ensure that absolutely everything that you do in terms of research, ideas, preparation, and writing is entirely your own. I will allow you to confer with others, so you may discuss the content of the paper. However, please be warned, the final answer must be yours, and I will very diligently, in relation to this assessment work, check with Turnitin for originality. So you may share ideas, but you must retain something that's of your own response. And what it means is that you can't collude, you can't act together to cheat or plagiarise or engage in academic misconduct, but you may discuss the matter. If you want some further information in relation to academic misconduct, my recommendation is that you check with the integrity policy of the Central Queensland University. If you can't access that, please put in a question. I suspect by now you're all quite familiar with misconduct and academic procedures and academic policies. All right, so that's the take-home paper. Are there any questions before I move on to other things that we're going to talk about? Okay, all good? Excellent, all right. Well, I've worked with some of you in the past, some I haven't worked with previously, but perhaps from the first assessment, you've got some idea of what it is that I expect. And if you've worked with me in the past, you'll probably know that anyway. All right, just be aware also that even though this is a take-home paper, not an assessment, I still expect you to refer in the way that you would for an assignment, in particular by ensuring that you comply with the Australian Guide to Legal Citations, make sure that you look at AGLC 4 and follow those guidelines. I'll just share the screen for a moment. If you don't have your copy of the Australian Guide to Legal Citations, I'd urge you to obtain it and consider it carefully. Now, the 4th version comes with bookmark capacity, so you can research the material. It's very lengthy, and I don't believe that we have the handy little guide that we had in AGLC 3, but by having the bookmark facility and clear chapter headings, you should be able to find the material that you want very quickly. And given that we're in 2nd year now, I'm sure that we're well past me having to say, please ensure that it's in a proper footnote. Make sure, for example, some basic things like the footnotes end with a full stop. One little bugbear of mine, please ensure that footnote superscript numbers appear after the relevant punctuation in the text, not before. Make sure that if your quotations are more than 3 lines, then that is a separate paragraph indented, and make sure that you have a proper means of identifying short titles. So if you're going to abbreviate material, for example, if you don't want to say the full name of the Mabo case every time you say it, you can abbreviate, which is brackets, single apostrophe, Mabo, close single apostrophe, close bracket, etc. Are there any questions about footnoting, what I expect from you? Any
John,
issues that you've had?
John,
yes, Jack.
Just a fairly easy one. So, if for those who aren't across AGLC 4 and have AGLC 3 quite sort of in the memory, the authors have actually released a guide of exactly what's changed. So if you're sort of in a bit of a time crunch, you could I think you might be able to get away with having a look at what sort of has changed to see if it's relevant.
And I must say, Jack, I haven't seen that. So if that's something that you have available that you'd care to share through Moodle, I'm sure that I'd certainly appreciate it, and others might too. I probably do have it somewhere, but I'm not sure that I've got it at my fingertips. So thank you for that tip, Jack. So excellent. Gary reminds me, yes, I do have a little bugbear with adding page numbers, so please paginate your paper. It's just a nice little touch. We expect that. Any other questions? Do you want us to include the word count? Well, I always check it. Thank you, Emma. I always check the word count anyway, but you can include that. That would be a nice little touch. Thank you. And Jack's already got the reference for that link, so thank you.
Sorry, and that second one is that second link is the error trim, which is because there was a certain errors that were identified in AGLC 4.
Okay, thank you. All right, and I'll just share that now that Jack has provided it to us so you can see what it is. Thank you very much, Jack. And I've got a question from Paris I'll come to shortly, Paris. So here we have, courtesy of Jack, the summary of changes in the AGLC 4, which outlines the difference between it and AGLC 3. So thank you very much. Paris, with your paper, you can put in your name and your ID student number, or just your name. I don't mind. So I'll find it very quickly. So, and your own work. Nice try, Gary. All right. Any other questions, comments? All good? All right. Thank you. Compliment to you there, Peter. All right. Let's move on and talk about some of the more substantive areas of discussion for tonight. And I appreciate all of that feedback and that assistance that we've just had. One of the hallmarks of ADR practice is confidentiality. And confidentiality is one of the key legal issues that we must bear in mind for effectively most of the ADR practice that we engage in. Not so much relevant for arbitration, but certainly for mediation and things of that nature. So the idea of having the rule of confidentiality is that it ensures parties feel free to exchange information, make concession, make offers, and but against that, we've got to be careful that the parties don't deliberately attempt to use confidentiality as a way of excluding information that might otherwise be used in an open hearing because it was raised in a confidential setting. So do you understand what I'm getting at there? It might be seen as a form of trickery. So certainly when I undertake ADR sessions, I give an explanation as to what it is that I regard as that which remains confidential. And it's essentially those things where a concession is made or an offer is made. Where it's relating to something to do with facts or the basic scenario of the dispute, then that is, of course, even though it might be discussed in an ADR session, that doesn't have with it the protection of confidentiality. But apart from the general principles then, there are a question here from on the run. To practice ADR, do you need a legal degree and a practicing certificate? The answer is no. But generally speaking, those people that practice in ADR, certainly as mediators, are nationally accredited to do so. And likewise for arbitrators, for example, in the family law sphere, they are properly accredited to do so. Okay, now there are some statutory exceptions to the issue of disclosure of confidential information. Just to get you warmed up for this evening, can anyone come up with some ideas of when it may be that from a legal perspective, an ADR practitioner may disclose information that was otherwise protected by confidentiality?
When it's
Yes,
agreed
Peter.
by both parties.
Agreement of both parties? Yes. Anything else there? Thank you. Any other things?
The communication constitutes criminal conduct?
Yes, criminal conduct. Yeah, thank you very much. Particularly in the context of threats or imminent harm. So you've got to be a little bit careful about disclosure if it's criminal conduct. If someone admits that they, they ran a red light in order to do something, you probably wouldn't disclose that. But if it's a threat, if it's imminent harm, then yes, you disclose that. All right, so some good ideas there. What if you have an agreement that's struck at a mediation or conciliation and it's signed by the parties? What if one of the parties refuses to follow through with that agreement? Does the other party have the right to seek to enforce the agreement, which will mean disclosing it? What are your thoughts?
That'd be a binding agreement, so it's contractual.
So contractual, says Michael. So you would say yes, Michael?
It is cool. You've signed off on it, so I'd say yes, because it becomes a document most likely to be a deed.
Yep. Peter agrees with that. Look, I agree with that as well. I think otherwise there's no point having an agreement at a mediation if you can't enforce it. So yes, I would say yeah, that as well. What if somebody says something in court which is clearly contrary to what was said in a mediation, which you believe to be true, to the point where it's misleading the court? Do you think that you can lead evidence to say, no, that party is misleading the court? I know that through a confidential process, but I can't allow the court to be misled. Gary says, depends on the circumstances.
I would say potentially as legal practitioners we would, because we've, as part of our duty to the court, we have to ensure the smooth administration of justice, and that sort of overtakes confidentiality requirements.
Yes. So certainly if I was in that situation, the first thing I would do would be look at the practice rules. So that's the Australian Solicitors Conduct Rules and the Barristers Rules, respectively. But it may depend on the circumstances. But the general rule, of course, is that our obligation is for the administration of justice. And I think if it means giving evidence to counter that which is otherwise misleading the court in substantial way, then I think you could argue that that is an appropriate exception to the rule of confidentiality. And another one might be in relation to costs. Does anyone know about Calder Bank? Has anyone done civil practice? Does anyone know what a Calder Bank offer is? Any thoughts? All right. So Calder Bank comes from a case. It's basically that if someone wants to retain privilege in a written communication, the simple rule is at the top of the letter put without prejudice. You've probably seen that. A variation on that, which is Calder Bank, is to say without prejudice, save as to costs. What that means is that it's without prejudice unless we have a costs issue, an argument, then I'm going to retain the right to produce that letter or that communication to the court. So there are a few reasons, legal reasons, why you might be in a position to overcome or rebut the presumption in relation to confidentiality. Now, I mentioned without prejudice communications, that can be overridden under the general law in a few circumstances. So what are those circumstances? So again, we're talking about without prejudice communication, which is also known as without prejudice privilege. So we're really getting into a bit of evidence law here now, aren't we? We're starting to talk about what may be privileged and what may be otherwise evidential. So without prejudice privilege can be overridden if the parties are engaging in misleading or deceptive conduct, would be one thing. That through the communication, the parties have created a contract, would be another, which follows on from what we discussed about being able to enforce an agreement at a mediation. Another rule, a common law rule would be if disclosure would prevent a court from being misled, which is what we talked about earlier. If the communication constitutes criminal or tortious conduct, that's the general law. I refined that a bit when Jack, I think was it Jack, was saying, you know, criminal conduct, I'd be a little careful about seeking to override without prejudice communication for all criminal or tortious conduct, but that's the general principle, which, and I think it's referred to in your textbook.
Would that sort of be a
yes, Jack?
John, would that sort of be a bit of like a gut call, like a go with your gut on that one, sort of like if
yes,
if it's like a sort of particularly heinous crime, like, you know, sexual misconduct or something?
You've got to be really careful with it, but yes. But bear in mind, it's not disclosure of things that have happened in the past that would warrant the ability to give the communication. It's really talking about actions that in themselves constitute the crime or the tort, or if that which is said constitutes a threat which may have an impact on the future. So if someone makes an admission in relation to criminal conduct for example, during the course of a mediation as part of without prejudice discussions, I would be, my initial feeling is I'd be reluctant to disclose that on the basis that you have an obligation to do so. It's a bit of a fine line, but the starting point, as I mentioned, is always look at the practice rules and the solicitor's conduct rules in particular. So some good thoughts there. Another exception, general law, and this comes from the case of Field against Commissioner for Railways, which was in 1957, a New South Wales case, is if the communication is not truly to do with settlement negotiations.
Do you have to bring up people I know?
Oh, is that right, Peter? This was the personal injuries case, wasn't it? Did you know? It's Mr. Field, isn't it?
Yeah, it's funny you should mention that, because I know the Fields are a very big family around Darugalby and Park, and so I know them. And don't mention the New South Wales racing club against Betfair, because I was involved in that one too.
There you go. Isn't it good that you've got some personal knowledge, some inside information about these cases? That's good. So they are real cases. They deal with
Too much,
real
I'm
people.
afraid.
Very good. All right. So we've been talking a little bit about without prejudice privilege, without prejudice communication. Now, in your text, David Spencer says it only applies to civil litigation. I'm not convinced by that. And I say that from a practical perspective. When I'm dealing with criminal law matters, I will often have without prejudice discussions with the other party, whether it's defence or prosecution. And the courts expect that, and it's now built into the process of case conferencing from a criminal perspective. Now, I mentioned this, I think, briefly in passing. I'll mention it now so you're very clear on this. In the paper, there will not be a question in relation to justice mediation. There won't be a question about criminal law mediation or ADR work in your take-home paper. It's not an easy paper, I'm afraid, this year. So I'll give you that little concession so you don't have to study quite so hard. All right, so without prejudice communication, civil litigation, certainly, that's what David Spencer says it only applies to. I'm not sure. I think you can go a little further than that. It's not restricted to just what lawyers say. We might think about without prejudice communication as something that is discussed between lawyers, but it can be for people who are not legally trained as well. Does anyone know the lead case that is authority for that proposition? It was a family law decision from 1964. The citation is 114 CLR 608 from 1964, and it's the case of Rogers and Rogers. So in that case, before litigation commenced, a separated couple went into a lot of correspondence. They did that through the lawyers as well as directly. And during the communication, the husband disclosed considerable detail about his financial position. Now, I think this would have been changed if it was decided by the court today. But in 1964, when the court did decide it, the High Court held that the family court should not have used that information as the basis of an award in favour of the wife. The parties in their disclosure had not used the magic words without prejudice. However, the parties were clearly attempting to reach a settlement ahead of the litigation, and when the husband disclosed that, it was regarded as confidential. And Michael says we covered that in evidence. I think, did we work together on that one, Michael, in evidence when I was?
Yeah, we did, like a semester ago.
Thank you. So I do rehash some of these cases from subject to subject that I take. So thank you for that, reminding me about that one. So that's Rogers and Rogers. Now, there are some exceptions to the operation of the privilege that we've discussed. So the without prejudice privilege may not fully apply in some circumstances. We've already discussed some of these. Number one is waiver. If the parties say, all right, it's my privilege and I will waive it. Now, trap for young players, of course, is that the privilege in relation to legal discussions is held by the client. So if the client says, I release you, Mr. Lawyer, Madam Lawyer, from the legal professional privilege, then the lawyer can't say, I'm claiming privilege, because it's the client's privilege. I hope that makes some sense. Other circumstances where there can be an exception to the privilege, against the same principles. You can't, if it means preventing the court from being misled, or it means enforcing a concluded agreement between the parties as to what was actually agreed. An older case covering this is Walker and Wilshire. 1889, 23 QBD 335, and that case established the basic principle that if the terms proposed in a without prejudice letter are accepted, in other words, we then have a contract, the contract is established, and although the letter originally said without prejudice, because we've now got a contract, we've got a new state of things, that overtakes the old state of things. So the privilege no longer applies if it's waived, or if the privilege or the communication was the first part of a concluded contract. So all good with all that? And then finally, I mentioned Calder Bank. The case citation is Calder Bank against Calder Bank, 1995, 3 All England reports, 333. So a Calder Bank offer is that which is without prejudice, save as to costs. All good? Now, can anyone tell me if there is some statutory basis for issues around the confidentiality of evidence in the context of settlement negotiations generally, including specifically ADR processes? I've talked about some case law, I've talked about some general law, talked about first principles, but if a judge says, what's your authority for that? Do you have any statutory provisions that you can refer to that might assist? Any thoughts? Yes, Jack?
The Civil Procedure Act.
In Queensland, absolutely. What about at a Commonwealth level?
Federal Court of Australia Act.
Yes, that's part of it. There are a couple of others and we'll deal with those now, but very good. So there are 2 of them. Let's start by looking at the Evidence Act, 1995, Commonwealth. And if you've got this on your screen, please do so. Just as a guide, if you can't get yourself to the Federal Register of Legislation or OSLE very quickly, then it probably means your bookmarks aren't good enough. So make sure that you have good bookmarks so that you can get to these things with speed. Let's have a look at the Evidence Act, 1995, Commonwealth, and I'll refer you to section 131 of the Act. So section 131 is in part 3.10 privileges. We've mentioned tonight client legal privilege. Don't worry about journalistic privilege, but do consider evidence excluded in the public interest, and in particular, section 131, which provides for the exclusion of evidence of settlement negotiations. So the communication made between parties in a dispute or between one or more persons and a third party in connection with attempting to negotiate a settlement of the dispute or a document for that purpose is not evidence that may be lawfully adduced. So again, Michael, we're going into the area of evidence law, but there's a crossover between evidence law and ADR practice. So section 131 of the Commonwealth Evidence Act. So where I agree with David Spencer is in this regard, that this evidence, sorry, this provision relates to civil matters and does not include an attempt to negotiate the settlement of criminal proceedings. So there's no mention of that in this section. The section only relates to civil matters. So my comments earlier relate to things other than that contained in the Evidence Act. Stop the share for a moment. So we'll talk about some other pieces of legislation. Jack's already identified a couple of them. But I mentioned earlier legal professional privilege. You saw that in the Evidence Act. And I mentioned that it's the client's privilege to waive, not the other way around. So legal professional privilege attaches to certain things, basically communications between lawyer and client, or documents brought into existence for the dominant purpose of existing or contemplated legal proceedings. Now, there are some exceptions to this. I won't go into it. We cover this a lot more in evidence law, but it also applies in relation to confidentiality in commercial matters as well. And Gary asked the question, must the waiver be held in writing? No, the waiver doesn't have to be in writing, but of course, if you are relying upon that which was said to you and it's not recorded in writing, a good practice is to immediately dispatch a letter, presumably an email these days, to the other side, referring to the conversation and referring specifically to the fact that they have waived their privilege in the verbal discussion that you had, so that it's in writing. And it helps in terms of evidence then, that you can produce this. It's something that was produced immediately after the conversation, puts the onus back on the other side if they wish to dispute what you're saying. Now, this issue is relevant in the context of arbitration, and have a look at the decision of SO Australia Resources against Plowman. That's Plowman, SO v Plowman, 1995, 183 CLR 10, and the High Court was not prepared to imply a term of confidentiality in relation to information disclosed during arbitration. And again, if we go back to first principles, if we look at that continuum, that chart that I've referred to many times on page 3 of your text, arbitration is of course the most court-like. So some of the things that we'd expect that would be within the mainstream of ADR practice, mediation, conciliation, won't necessarily apply to arbitration. I think that's really a misstatement to say or suggest that arbitration is not mainstream. It is very much mainstream, and it's becoming far more so, particularly in the context of, I'm digressing for a moment, but we tend to think of arbitration as relating to the resolution other than through a court by the imposition of a decision by the arbitrator in commercial matters, construction matters, things of that nature. But increasingly, arbitration is being now pushed with great force in what area of practice? Can anyone get, I know I'm diverting here. I'm digressing.
Family law.
Family law, absolutely, Peter. Thank you. Yes, in the Family Law Act 1975, there was no mention of the ability for arbitrators to make the decision instead of a court. Then I think in about early 90s, it was brought in, but it really wasn't regulated to any great degree. And then I think in about 2016, so only recently, it's become regulated to a far greater degree. And if you're thinking about arbitration in the context of family law, the starting point is to look at the Family Law Act. I think it's around section 10 through to 13, that sort of area. See where it applies, to what it applies, and importantly, how you become registered, how you become accredited as an arbitrator. It's not like being a judge where you're appointed by the Attorney General. You need to go through a process. I haven't been through this process. The number was very modest only a few years ago. The number is increasing, but if you're thinking about an area of practice, you wish to be an arbitrator, I think family law is absolutely a growth area, and the numbers are increasing year by year pretty quickly now. But you need to go through a process, so have a look at the family law regulations as well as the Act. All right, now I'll get back on topic. We're talking about statutory privilege. Now, I think, was it Jack, you mentioned the Federal Court of Australia Act?
Yes.
Thank you. So let's have a look at the Federal Court of Australia Act, because that's absolutely correct. And I'll share the screen. So Federal Court of Australia Act. Again, whenever you're looking at legislation, think back to our statutory interpretation days, where you want to look at the headings, get a feel for the Act, get an idea of where things fit. And the relevant section is section 53B. So if we pan down, the problem with federal legislation is that we have so many sub-paragraphs that it becomes quite unwieldy. But in part 6, general, dealing primarily with practice and procedure matters, you'll see section 53 capital B, which talks about admissions made to mediators. And if we click on that section, you'll see that evidence of anything said or any admission made at a conference conducted by the mediator in a course of mediating anything referred to under section 53A is not admissible. So again, it's like the Evidence Act, isn't it? It's not admissible in any court, whether exercising federal jurisdiction or not, or in any proceedings before which a person authorised by law is to hear evidence. So that's the Federal Court of Australia Act 1976, and it works in conjunction with the earlier piece of legislation. Now, at a Queensland level, and I'm sure it was Jack mentioned the Civil Proceedings Act 2011, and again, I totally agree. Have a look at section 36. So again, when you don't just go straight to 36, as a practical guide, make sure that you read the parts, get a feel for where this fits in, and you'll see this is in part 5, conferences. And section 36 says that evidence of anything done or any admission made at a relevant conference about a dispute is admissible only if the parties agree or the evidence is an agreement under section 35. And it talks about civil proceedings, not including civil proceeding founded on fraud alleged to be made during the conference. So in that subsection 2, we see the exception in relation to some degree of criminality, fraud. But bear in mind if you look at the name of the Act, this is the Civil Proceedings Act. And again, that's part of why David Spencer says that the privilege only applies in civil matters, but for a part of the unit that I normally teach, which is criminal mediation work that I'm not going to cover in any great degree, as I mentioned earlier, there are procedures that allow for the confidentiality process in criminal law matters as well. All right, I'll stop the share. Any questions as we go? All right, so that's section 36 of the Civil Proceedings Act 2011, which is state-based legislation. Just as an aside while I think of it, in relation to the take-home paper, I do want the work to be a learning experience for you as well as an examination process. And I want it as much as possible to be practical and useful for you. So if you happen to live or practice in another state or territory in Queensland, and you believe that the answer that you give can be usefully done by reference to your own state or territory legislation, then go with that. Even though it may refer to Queensland, go with what legislation you're familiar with, works for your state, and I'll do the extra research to make sure that I mark it appropriately. All right, so all good. Again, that's a general rule with me on all the units that I take, but don't assume that that's something that other unit coordinators would wish to do. So be guided by them. All right, so now, one of the things that we've really been touching upon, but we haven't really dealt with entirely, is issues to do with the liability of ADR practitioners for things that they might say or not say, and immunity. So an ADR practitioner, generally speaking, can be sued, but in limited circumstances. This is the general rule. An ADR practitioner can be sued over procedural issues, but it's much more difficult for a party to successfully sue or attempt to sue an ADR practitioner over substantive issues. But potential liability for an ADR practitioner might be in contract, so a breach of contract, because the agreement is likely to be a contract. The ADR practitioner might be sued for torts, negligence, for failure to comply with duty of care, breach of the duty of care, where there's actual loss or damage sustained. But of course, the plaintiff will need to be able to prove the connection between the negligence and the loss, as is always the case with torts. And note the statutory immunity, Section 52 of the Civil Proceedings Act, 2011 Queensland, provides for statutory immunity, and also have a look at the Federal Court of Australia Act. We've talked about enforcement of agreements, and the law of contract applies in the usual manner for a breach of contract in relation to a settlement agreement. So generally speaking, the way to enforce an agreement through ADR practice is in the usual manner, by suggesting that the contract has been breached. But there is an earlier topic that we need to consider, and that is very often we see issues where an ADR clause is built into a contract, or a dispute resolution clause is built into a contract. We call this a Scott and Avery clause. So a Scott and Avery clause is where the parties agree by contract to involve a dispute resolution process as a condition precedent to litigation. We saw that a bit last week as well in our discussion. But the parties may not contract to oust the jurisdiction of the courts. So the question is, then, to what degree, how do we go about interpreting these clauses, and when can the court become involved where the parties have a Scott and Avery clause built in? So we'll look at a few cases here. They're referred to in your text, so please follow the text in that regard. The first one, which is an example of a hardline approach adopted by the courts, is Elizabeth Bay Developments against Boral Building Services, and it's 1995 1936 New South Wales, Law Reports 709. So what happened in that case? The courts considered an ADR clause. It was very detailed. It referred to two external documents that were not annexed to the contract, and the external documents were inconsistent with each other and inconsistent with the clause. So it was essentially poor drafting that probably led to the dispute in Elizabeth Bay. So the guidelines in the appointment agreement didn't create sufficient certainty in the process, and the parties had agreed on mediation appointment without agreeing to the terms, and it was held to be unenforceable. Now, the other issue that often crops up in this context is the argument about good faith. And we've talked about this good faith a little, but you'll need to be aware of this for the potentially for the end of year take-home paper. So on the separate good faith issue in Elizabeth Bay Developments, Justice Giles reasoned that the phrase aim to determine and commit a party to a state of mind in the future, which cannot be possessed with certainty. It was claimed that good faith and self-interest were mutually exclusive, and in that case, the term or the clause failed. Now, another hardline approach is AITON, A-I-T-O-N, Australia against Transfield, and this is 1999 153 FLR at 236. And a mediation clause was found to be uncertain because the mechanism for the apportionment of the mediator's costs was not certain, and that clause was not severable from the agreement. Peter was also involved with that one. Peter, you know this week's material because you've lived it to some degree, so that's good.
You're not wrong.
Very good.
Getting a bit monotonous.
I should be getting you to talk about these things.
I
So,
don't think so.
no, that's all right. So also look at that case in relation to Justice Einstein's comments about good faith and whether or not good faith can be inconsistent with acting in one's best in self-interest. So the idea here is this, this potential argument that, well, how can you act in good faith if you've also got to act in your own interest? And so, for example, in that case, Ayton and Transfield, the court ruled that the obligation to act in good faith is recognised as an implied obligation, and it doesn't require you to champion another's cause over your own interest. So the law is a little unsettled as a result of that. Now have a look at another case, which is more a moderate approach, which is Computer Share against Perpetual Registers. That's a 2000 decision. And then look at United Rail Group against Rail Corp from 2009. You shouldn't. And that's a comment to Peter there, if you're watching this as a recorded session. All right. I will refer you to this, and I know time is getting away, but I'll share the screen because I want to refer you to an excellent online resource that is from the Law Council of Australia. And under the Resources tab, particularly in relation to that which relates to ADR, we have some relevant material that might help you. One is Ethical Guidelines for Mediators, 2018. Another is Guidelines for Lawyers in Mediations and Guidelines for Parties in Mediations. So there's some valuable resources that you need to consider. In that, there'll be some commentary in relation to the standards that apply in relation to court annexed ADR, and you'll see some reference to what is good faith. Just on that point, in terms of good faith, then we have some other material that you might want to consider. For example, this is the Administrative Appeals Tribunal Act, 1975, and I'm going to refer you to section 34, capital A. Now, where is 34A? So 34A is under Part 4, Reviews by Tribunal of Decisions, and Division 3 deals with alternative dispute resolution processes. Then we go to section 34E and 34A. So 34A talks about a referral for alternative dispute resolution processes, and 34E has the now familiar type provision that evidence is not admissible in relation to that which was said or act done during an ADR process, and that's not admissible in a number of ways. So the policies and guidelines of the Law Council of Australia deal with, amongst other things, that which I've just referred you to in administrative law. Another place where you can look, and this is the last thing for tonight, is again NADRAC. And if you're looking for information around this topic, NADRAC has a document called Maintaining and Enhancing the Integrity of ADR Processes from Principles to Practice Through People. And that is a publication that I would commend to you. It was 2011, I believe that was prepared. All right, so next week, Courtney was saying, was that the first case about good faith? What was the first case? All right, I'll just go and mention some of the cases. So the first one was, thank you, Courtney, Elizabeth Bay Developments against Borrell, 1995, 1936 NSWLR 709. That was a hardline approach. Then look at Ayton Australia against Transfield, 1999 153 FLR 236. Hardline approach, read the case or just ask Peter and she can tell you all about it. Moderate approach, computer share against perpetual registrars from 2000, and then finally United Group Rail Services against Rail Corp from 2009, and I believe all of those are referred to in your text. So I hope that helps. All right, so next week we will talk about ethics and standards. We'll also talk about other issues, special issues to do with ADR practice. And then we're leading into week 12, which is the take-home paper. So thank you very much for your patience. You've been very good tonight, as always. Any questions, comments before we wrap up for this evening? All good?
John, I have a quick question.
Yes, Emma?
Not directly related to this week's topic.
That's okay.
But I sat in on a case recently. It was the Victorian Legal Services Board against a lawyer. Anyway, he had advised his clients not to participate in mediation. And because the clients didn't participate in mediation, it all went really bad for them. And that was the purpose of their complaint to the Legal Services Board. And he was charged with professional misconduct, if you like. So under what circumstances would you advise clients not to participate in mediation?
It would be rare for me not to advise that. I don't know the case and I don't know the individual concerned, but I can make a general comment. In the 80s, we basically didn't know about mediation much. And I remember a mate of mine went through school and university. He was in a totally different field, but he went to America, came back, and this was in the early 80s, and said mediation is being taken up over there. It might be something for you to look at. So I was in really amongst one of the first ones to be trained into it. But the point that I'm making is this, very slowly, a lot of practitioners did not take up on mediation or ADR practice quickly, and a lot still just don't see the point of it when we should be going to court and resolving it. Now, so it may be a tactical issue. And generally when it comes to tactical issues, I think, one's view does not necessarily mean that it's right. And there might be a completely different view. Don't go to mediation. We'll get a much better result if we go to court, seek an injunction, for example. Let's not talk about it. Let's take some action. So, I'm not sure that I would necessarily say that there are any circumstances, but that's one that comes to mind. If you need to take immediate action to protect a position, to preserve a situation, then you might want to take that action first, Anton Pillar order, a Morava injunction, for example, and then once you've preserved the position and you've got a strategic advantage, then you might want to open up to mediation. That's just one thing off the top of my head. I hope that answers your question, Emma.
John?
Yes, Peter?
One thing I can say about that Betfair and Racing New South Wales particular case, that actually ended up in the High Court with that was about the whether the Betfair, which was a betting company, should pay for the race fields, which they weren't paying for up until that stage. New South Wales had passed legislation to say that they should actually pay 1.5% of their turnover into to the various racing clubs, be it Racing New South Wales, Harness Racing New South Wales, at that stage. It ended up in the High Court, and the mediation totally failed in that particular situation, and that came down that yes, that was legitimate legislation. They should pay the 1.5%, which ended up releasing something like $51 million back into harness racing New South Wales for starters, and it was negotiated in Victoria, a similar sort of situation. They took the negotiated view, and they ended up having to pay Betfair money because it wasn't sort of making a profit in Victoria. So it was well worth putting up with the discomfort for those few years that we put up with it for.
Very good. But it's interesting what you say, coming back to Emma's point, that perhaps sometimes mediation won't be successful. It wasn't in that case. I'm not sure that that is a good reason for a practitioner to say, don't go to mediation. But no, I agree with you, Emma. Your comment that it was a little surprised you would have thought that mediation would have been valuable. And I think generally speaking, some form of ADR practice is valuable. And I guess for the purpose of the examination now, just to segue a little, don't fall into the trap of always just thinking mediation is the only ADR option, but you know that from our discussions over the last few weeks, there's a whole range of them. All right, so some good discussion and questions there. Thank you, Emma. Thank you, Peter, for that. Any other questions, comments? Oh, you're muted, Peter. You're muted, Peter.
That was the case that really went against the grain.
Oh, okay. Yes. Yes, that's right. That makes sense. All right. Well, thank you all, and we'll see you next week. All the best. Bye then.